Amazon fills nearly 12 million orders a day, but when 84 delivery drivers became a union, it wasn't just a workplace dispute. It triggered what is turning out to be a legal showdown that could reshape how labor laws apply across the country. The outcome of this case is now about a lot more than Amazon. So by the end of this video, you'll understand why the NLRB ruled that Amazon is a joint employer, how that decision affects workers' rights across the country, and why Trump's removal of one NLRB member could shift the future of union protections and labor enforcement in the US. Guys, this isn't just about Amazon, though. It's about whether powerful companies can still be held accountable when they control the work that is being done, but they outsource the liability. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. And on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace. Whether you are an employee who is trying to protect your rights or an employer trying to do things the right way. So in late December 2023, an NLRB regional director ruled that Amazon qualified as a joint employer, which forced the company to face consequences for refusing to negotiate with unionized drivers. But here's the catch: the NLRB's ability to protect those workers and workers like them is already under threat. That's because in 2024, Donald Trump removed Gwynne Wilcox, one of the board's strongest pro-labor voices, and that decision could drastically reshape how cases like the one we're talking about today, how they are decided moving forward. Today's case is focused on Amazon, but if you haven't already seen my video on Gwynne Wilcox's removal from the NLRB, I recommend checking it out, because that decision is a turning point, not just in this case, but in future labor rights across the country. Okay, let's talk about it. The content shared on this channel is for informational purposes only and shouldn't be taken as legal advice. Always consult a qualified attorney or HR professional for guidance on your specific situation. And hey, don't forget to like and subscribe. Amazon fulfills over 11.95 million orders every single day. But here's the part most people don't realize: Amazon doesn't deliver those packages on its own. Instead, it outsources the final stretch, what's called last mile delivery, to a network of over 3,500 delivery service partners, or DSPs, around the world. Now, these DSPs hire the drivers, operate the vans, and handle the actual drop offs to your doorstep. From the outside, it looks like these are completely independent businesses, but behind the scenes, Amazon controls a lot. They set delivery routes, they dictate delivery schedules, and they even set minimum pay standards. So while these drivers don't technically work for Amazon, Amazon still calls a lot of the shots. So let's take a moment to break down what it means to be a joint employer, because that's really at the heart of this entire case. A joint employer is exactly what it sounds like. It's when two or more companies that share control over the same employee. So that means if you work for one company, but also another company controls important parts of your job, both companies can be held responsible, legally responsible, for how you are treated at work. What we're talking about is who really has control over the job, who decides how much an employee will get paid, who sets the schedule, who tells the employee what to do and how to do it, and whether or not they're going to be terminated or written up or promoted. If one company officially signs the paycheck, but another company is actually calling the shots, like telling the employee what time to show up, how many deliveries to make, or how fast to do the work, then both companies can be held legally legally responsible for how an employee is treated at work. That's what it means to be a joint employer. And that matters big time because once a company is considered a joint employer, it can't dodge accountability just because it outsourced the job. They may have to bargain with the union, they may have to follow the workplace protections, the laws, and they could also be held liable if an employee's rights are violated. And in today's economy, guys, this is such a big deal with all the gig workers, staffing agencies, and franchise models everywhere. This issue affects millions of people. And that's exactly why this case with Amazon is such a big deal because it tests how far the legal responsibility really goes. And so here's how all of this came about. In Palmdale, California, around 84 delivery drivers who were employed by a DSP called Battle Tested Strategies, they voted to unionize with Teamsters, and the drivers negotiated a contract with Battlefield Tested that included immediate wage increases, commitment for future raises, and safety provisions that were tied to the conditions of the vehicles that they were driving. But here's where things got complicated. Many of the contract terms would also require Amazon to give input or approval on wages, routes, and schedules. So when the union notified Amazon of the contract and asked Amazon to recognize it, Amazon flat out refused. And what they said was, hey, DSP, these aren't our employees, they're your employees, and told the employees, talk to the DSP. And in response, the drivers, they went on strike, and Amazon then terminated its contract with Battle Tested Strategies. They just stopped working with them altogether. So that move is what prompted the Teamsters Union to file charges with the National Labor Relations Board and accused Amazon of unfair labor practices, including failing to bargain in good faith and retaliating against the union activity. In response, Amazon tried to distance itself by saying that it had no legal obligation to bargain since the drivers were technically employed by battle tested strategies. But the NLRB, that regional director, disagreed with Amazon's position. After a detailed investigation, the NLRB decided that Amazon did, in fact, have enough control over key working conditions like pay, the route that they were taking, the scheduling of those workers to be considered a joint employer under labor law. And being a joint employer carries consequences. It means Amazon could be held responsible for violations of collective bargaining rights. And the ruling in Palmdale wasn't a one off either, because in Atlanta, Georgia, a similar NLRB case was taking place where Amazon was again accused of interfering with union activity by DSP drivers. The message from the NLRB was clear. If a company controls the work, they can't hide behind subcontractors to avoid responsibility. It's important to know that the whole idea of a joint employer, it's one of the most debated topics today. Right now, the rule says that a company can only be called a joint employer if it's directly controlling the important parts of an employee's job. But in October 2023, the NLRB, they tried to broaden that definition. They said even if a company isn't actively controlling the job, if they just have the power to step in and control it, that should be enough. And that was a big shift because it meant companies couldn't just say, we didn't do it if they were sitting in the background with the power to pull the strings. A federal court struck down that rule in March of 2024, but the fact that it even got that far, it shows just how divided this issue is and how high the stakes are for both employers and workers. So, if Amazon ends up losing in these cases, it would send a clear message. Companies can't hide behind subcontractors or partners just to get around labor laws. And that wouldn't just change things for delivery drivers, it would impact millions of people working in gig jobs, staffing agencies, franchise chains, in all types of positions all across the country. So, where does Gwynne Wilcox fit into all of this? I mentioned her at the beginning of this video, and if you want a full understanding of her story, I highly recommend watching my separate video that was all about her removal from the NLRB. But here's the key point. Gwynne Wilcox was a strong pro labor voice on the National Labor Relations Board. She played a major role in shaping how the board handled joint employer cases. She also was an advocate for workers' right to organize. But in 2024, President Trump removed her from the board. And this wasn't just a political move, it was a very calculated one because her removal shifts the balance of the board, making it more employer friendly, especially for companies like Amazon. Wilcox stood for the principle that if a company controls your work, it should be held accountable, even if you're officially hired by someone else. Now that she's gone, future decisions could tip in favor of companies, not workers. And the kind of accountability we're seeing in Amazon's case, well, that might not last if the board becomes less aggressive in protecting labor rights. The Amazon case is far from over, but the bigger story is what it represents. It offers a glimpse into the ongoing power struggle over who is truly responsible for workers in today's economy. When many of our key labor laws were written, there were no gig platforms, no franchise chains, or staffing agencies operating at the scale we see now. Those kinds of employment relationships simply didn't exist, and the law is still trying to catch up. And if the NLRB grows weaker, if voices like Gwynne Wilcox are pushed out, if workers may not get this kind of protection again. If you want to understand how these labor battles shape your rights at work, subscribe to the HR Insider because I break down legal cases, the power dynamics, and what it all means for real people trying to earn a living. Thanks so much for watching. If you want to understand why this case may be the last of its kind, check out my video on Gwynne Wilcox's removal from the NLRB because her departure could change the way future cases are handled. And it is a very important aspect of what's happening right now. I'll link it here on the screen and in the description below. And if you found this helpful, please consider subscribing to the HR Insider. I cover real cases, workplace rights, and stories behind the headlines because you deserve to understand the rules that shape where you work. Thanks again for watching. I'll see you in the next video.